Okay, we welcome to the Bob Unger Show the extremely erudite Edwin Vieira. Edwin, I don't know whether we can give credit to Harvard. He's got 4 degrees from Harvard, law degree, a PhD, a master's degree, I think a BA as well. And I don't know whether his erudition comes from Harvard or whether he's an autodidact.
Well, it could be both.
That's what I was thinking,
That's
a hybrid.
That's right.
And you've also written a number of books. Could you name and a brief explanation of the books you've written?
Well, most recently, I've written a number of books dealing with the constitutional militia question, Sword and Sovereignty, 13 Rights, 13 Words, 3 Rights, Constitutional Homeland Security. Those are the titles of 4. I wrote a very long treatise, 2 volumes, on constitutional money called Pieces of 8. Written quite a few articles in scholarly journals of one sort or another, of course, on the internet, been interviewed on these subjects. So my basic interest has been in constitutional money, the constitutional militia structure, and peripherally to those, the First Amendment, due process, equal protection, kind of the basic foundational principles of constitutional law. And
you've also argued cases before the United States Supreme Court.
Oh, yes. Argued of brief cases, won 4 out of 5 of them, actually. Wow. And then, of course, a lot of them that never get to the point of an actual decision, they go up on certiorari or some other kind of procedure, and there's a perfunctory decision come out of the Supreme Court. They don't hold a complete oral argument and the rest of that. But otherwise, I've had a fairly good experience there.
Well, 4 out of 5 would make any baseball player very jealous with that batting average.
Yeah, I would think so. I would think that would be fair.
Okay. So now that we've given out your curriculum vitae to a degree, did you also make some documentaries?
Oh, yes. I've been talking head on quite a few documentary productions dealing with fiat money, that's the title of one. Cultural Marxism, that's the title of another. Couple dealing with the Second Amendment. So they're out there. I think if people look me up on the internet, they'll find those and a number of interviews and things along this line that I've done.
And when you say fiat money, for the benefit of some people that may not be familiar with the term, you're referring to money that is mandated by government fiat or government edict. And of course, today you're referring to paper currency as opposed to gold or silver. Is that correct?
That's right. The Federal Reserve System's currency now, which arguably is not even a constitutionally based currency of the government at all. I mean, again, all sorts of questions about it. But that's the basic idea. Fiat comes from the Latin, let it be. All right, someone has declared this thing to be money when it really isn't. And that's where the problems begin.
So the thing that most people think is money, the thing in their pocket with pictures of presidents on it, is not, in fact, money, but nothing but fiat currency.
It's a substitute for money that has been required by some statute coming out of Congress. The actual money of the Constitution has to be gold or silver coin. You could generate from that what used to be called gold and silver certificates, which were essentially trust documents. The coinage was in some vault somewhere in the Treasury. But what we have now has no real connection to gold or silver. It has no absolute legal connection to any commodity. There's no legal requirement in the country that anyone actually has to use gold and silver. If I want to value my services in something other than gold and silver, I can do that, or in gold and silver, or in Federal Reserve notes. It's all a fantastic fiction that's been provided since the 1930s, because from 1913, when the act was passed, up until 1932 and 33, when Franklin Roosevelt took the country off the so-called gold standard, the Federal Reserve System really was based on a gold coin standard. That's how they got it sort of past the censors in Congress, if you will. That's how they sold it. That was the bait and switch argument. And then at the first opportunity, or the first problem that arose, the first emergency that arose, they went off the gold standard entirely. And then subsequently, we've gone to a non-standard. It's basically a paper standard, electronic standard. There is no real commodity legally backing Federal Reserve notes.
And today, of course, the so-called currency has the words Federal Reserve note at the top. And of course, in law school, we both learned that the definition of a note is that it's simply basically an IOU.
Right, exactly.
It's not money, and it depends on somebody else following through on a promise. That's all it is.
That's right. So what you have now, treating this historically, is a dishonored promise, because the original promise in the Federal Reserve System was that the Federal Reserve banks or the U.S. Treasury had to pay gold in redemption of the Federal Reserve note debt instrument. And they've now removed that redemption proposition. Actually, you can still, I suppose, if you wanted to, you could push it to the Treasury and you would receive the base metallic coins, the Susan B. Anthony coins, the state quarters, and so forth and so on. But those are not the gold and silver coinage that the Constitution requires. So we've come a long way from the constitutional system there, with the necessary consequences that any good economist will tell you follow from the introduction of fiat currency.
And what does the Constitution say about gold and silver as money?
Well, if you look at the Article 1, Section 10, Clause 1 prohibitions on the states, because remember, when this whole system started, the states were separate sovereignties. They treated themselves essentially as separate countries. They had all the powers of a separate sovereignty. Article 1, Section 10, Clause 1 says, no state shall make anything but gold and silver coin a tender in debts. Well, what are we talking about? They basically are talking about every commercial transaction that you can imagine is going to be or involve a tender in payment of some debt. There's always a debtor on one side and a creditor on the other side of every one of those transactions. So that provision alone tells you that throughout the United States, the fundamental, the foundational structure of the monetary system was supposed to be gold and silver coin. Congress was given the authority to coin money and regulate the value thereof. And there's the important word, coin money. And in two places in the Constitution, one in the body of the Constitution and one in the Seventh Amendment, it uses the term dollars. And at that point in time, what was a dollar? It was actually a Spanish coin that had been adopted by the American commerce, Spanish silver dollar, Spanish mill dollar it was called. And that's what Thomas Jefferson proposed to the Continental Congress, and then proposed again, along with Alexander Hamilton, one of the few things that the two of them agreed on after the Constitution was ratified, that was to be the standard of our constitutional monetary system. So we know exactly what the standard is. It's this silver coin that contains 371 and a quarter grains of pure silver. And then the gold coins were to be coined and regulated in terms of their market ratio and purchasing power to that silver coin. And the states were required to use only gold and silver coin in tender of payment of debts. So the whole thing fits together perfectly. The founding fathers were not, what shall I call them, visionaries. This was not some system that they kind of made up out of their own heads. This was the way the economy of the American colonies and the American independent states was actually working at the time. They put this into the Constitution. And I think what they didn't foresee was exactly how dishonest and unscrupulous certain financial interests in the country working hand in glove with politicians could turn out to be.
Politicians being unscrupulous? No, couldn't be.
Well, maybe that's an unfair characterization, but we'll leave it at that for the
It's an unfair understatement.
Yeah, perhaps that's a better way to put it.
What did the founders actually say about paper money?
Well, Madison talked about the curse of paper currency. You read the Federalist Papers, they were very much against it, primarily because they had been involved with a huge paper money episode during the War of Independence. Right? The Continental Congress, number one, issued the so-called Continental Currency, which was supposedly redeemable, but they couldn't redeem it because they didn't have the power to tax. So they couldn't get enough real money coming into the Continental Congress to redeem this currency. And then many of the states put out their own paper currency, as they had been doing as colonies prior to the War of Independence. So the founding fathers were, as a matter of observers, they were right there while this was happening. In fact, some of them were the ones who were responsible for it happening while they were in the Continental Congress or while they were in the various state legislatures. And this is one of the amazing points of American history, that those same people turned around and essentially said, we made a terrible mistake here. We can't allow this to happen ever again. And so we're going to put into the Constitution strict limitations on that problem. No state can coin money. No state can emit bills of credit. That was their term for paper currency. The power was proposed to the Congress during the debates in the Federal Convention to give it the power to issue paper currency. That was turned down, and gold and silver coin were made the only tender in payment of debts. So it was clear what happened. It's clear what happened then, and it's clear what the law means. And then we see various permutations and combinations of political double talk and fraud, which have led us to where we are today.
I believe, if I'm not mistaken, that Thomas Paine suggested that anybody who would suggest paper money should be executed.
Well, at least exiled, I would hope. Well, you have to understand, they went through a terrible episode of paper money expansion, inflation, nearly ruined the country economically in the course of a war. So
That's
these
where
are
the
people
expression "not worth a continental."
not worth a continental. So these people had firsthand experience, not only as theorists but as practitioners.
Right, right. So they were kind of struck by reality, the lightning of reality.
That's right. And it was lightning that hit them because, as I said before, many of them were responsible for that inflationary episode when they were in the Continental Congress or they were in the state legislatures.
Okay, let's move to another constitutional subject, which is in the news now.
Oh, yes.
They're making a big mishigas, to coin a Yiddish word, about Trump hinting that Kamala Harris, the VP candidate of the Democratic Party, is not eligible under the Constitution to be vice president, as in not being a natural-born citizen. Explain what that term means as used in the Constitution.
If you look at the original Constitution, before any amendments were enacted, we have two terms that are used. One is citizen of the United States. You have to be a citizen of the United States to be a representative or a senator in Congress. The other is natural-born citizen. And you have to be a natural-born citizen to be eligible for the presidency. So that would include the president and the vice president. Then you come in the 14th Amendment to the terminology that all persons born or naturalized within the United States and subject to the jurisdiction thereof are citizens. So you have those 3 points in the Constitution which have to be intellectually integrated, legally integrated. And it's fairly clear in the original Constitution that a citizen is not necessarily a natural-born citizen. A natural-born citizen is always a citizen, but a citizen is not necessarily a natural-born citizen. And a citizen under the 14th Amendment, someone who happens to be born in the United States and subject to the jurisdiction thereof, he may be a citizen in that original term in the Constitution, but he's not necessarily a natural-born citizen. A natural-born citizen was a term that was derived from international law at the time, the law of nations as it was called. And it was basically the concept that your citizenship derived from your father's citizenship. Because at that time, women were generally not legally emancipated, as we say today. They were subject legally to their husbands, or in some cases, their fathers, if they were unmarried and minors. Right, so the concept there was that if the father's citizenship was imputed to the child, and if the father had the child in somewhere in the United States, but he was a French citizen, the child was a French citizen, all right? And that's where we get into the problem of Mr. Obama, because if his father was a Kenyan, then arguably he was not a natural-born citizen. And that's why I think Mr. Trump is distancing himself from this question, because once you open up the box of Ms. Harris, you open also the box of Mr. Obama. But if you look at Harris, her situation is clearer in a negative sense than Obama's situation. Obama's situation has lots of permutations and combinations of difficulty in it. Her father was a Jamaican. Her mother was an Indian from India, not an American Indian. And as I understand it, she never took out the necessary paperwork to begin the process of making her a citizen. So neither one of Harris's parents is a citizen. It would seem that that's where the inquiry stops. Neither parent is a citizen. You couldn't possibly be a natural-born citizen. Now, some people will argue that because she was born in the United States, she's a citizen of the United States. But that still doesn't make her a natural-born citizen. And of course, the other question, if both of her parents were foreign nationals, the mother an Indian, the father a Jamaican, even if she was born in the United States, she would not necessarily be born subject to the jurisdiction thereof. You have to remember the 14th Amendment was enacted way back in the 1860s. And one of the situations in this country at the time was that there were Indian tribes which were being treated as separate sovereign entities. You look at Article 1, Section 8, Clause 3 of the Constitution, the Commerce Clause gives the power to Congress to regulate commerce with foreign nations and the Indian tribes, as well as the several states. So the Indian tribes fit into this kind of separate situation. They weren't really foreign nations because they were physically within the United States, but they weren't really citizens of the United States because the people in the tribes owed their real allegiance to whatever tribal system they had. So you had treaties being made with those people all the way through the early 1800s, I think probably through the entire 1800s. Various treaties were made, treating them as separate political entities. So the people who wrote the 14th Amendment realized that, right? Indians had been around for a long time. They were certainly dealing with them in one way or another. And they wanted to make it clear that simply being born in the United States did not necessarily make you a citizen of the United States unless you were subject to the jurisdiction. The Indians weren't subject to the jurisdiction of the United States. They were subject to the jurisdiction of their own tribes, and therefore they didn't automatically become citizens. And we find out later they were made citizens in other ways, right? So if you look at that, it's fairly clear to say, all right, if you have parents, especially both parents, who are citizens of some foreign country, or in her case, two foreign countries, two different foreign countries, even if you're born in the United States, you may not be a citizen. And obviously, if you're not a citizen, you can't be a natural-born citizen. And she's not a natural-born citizen, even if she is a citizen, because both of her parents were foreigners. That's the basic legal argument. And you come back to there's really one case that deals peripherally with that called Wong Kim Ark, which was a case involving a Chinese immigrant in the United States. And otherwise, this question is pretty much up in the air. It really has not been settled one way or the other. And it was unfortunate that it wasn't settled during Mr. Obama's time, because that would have cleared up all the questions, because he had a different situation. He had an American mother, of course, and a Kenyan father, according to the story that he tells. And then he went to Indonesia as a child, had his citizenship changed to Indonesian citizenship, came back to the United States. Did he reaffirm his United States citizenship as an adult? We don't know. So there are all sorts of interesting questions in her case. In his case, I think in her case, it's a great deal more straightforward. But the question now becomes, will the political class in this country dare to raise this? Not only because of her, being the first, as they say, woman of color who's in a position to be president of the United States, but because when you open that Pandora's box, you reopen the Pandora's box of Mr. Obama.
And even perhaps this way, for people who accuse me of just being a Republican partisan, which isn't true, by the way, Ted Cruz would have major problems being eligible for president because his father was
That's right.
in Cuba.
That's right. And there was some suggestion of that at the time, which was essentially deep six in the media. They didn't want to talk about even though a lot of the media obviously didn't approve of Mr. Cruz. So, yeah, that's there. And I would think in her case, it's probably as clear as it could possibly be, given the nature of her parentage.
Yeah, no doubt. And wasn't one of the reasons for all this is that the founders wanted someone who was going to run for president to have more than just a first-generation American experience or connection with America. Whereas if his parents had been born in America and he was a second generation, there would be more of a bond or a nexus between that candidate and the country.
And yes, and that's very important because of the status of the President of the United States as what? Commander-in-Chief of the Army and Navy and of the militia of the several states when called into the actual service of the United States. He's in this position which mandates that he not have any loyalties to other countries, right? So if he's maybe first generation, non-natural born citizen, you'd begin to wonder about whether it would be possible for him to take into consideration in that particular circumstance some residual loyalty to where his father, his other ancestors were born, and what countries they were citizens of. So you see that in the Constitution. That's the only place. Of course, it doesn't say that a representative has to be a natural-born citizen. It doesn't say a senator has to be a natural-born citizen. It's only the President of the United States. And I think that's because of this position as commander-in-chief. Remember, the Founding Fathers were extremely suspicious of standing armies. Right? They didn't like the concept of standing armies at all. Nonetheless, they put in a provision that Congress has the ability to raise armies for limited periods of time, and they gave the power to the president, essentially the same power that the king had, as commander-in-chief of the standing army if it ever developed. So they were very careful to put this other consideration into the Constitution to make sure that there wouldn't be some lingering doubt in people's minds as to whether this particular individual running for president was really capable of performing that service in the interest of the United States.
Well, one of your statements a few seconds ago brings another question. You said, Commander-in-Chief, when called into service by the Congress. What exactly does that mean? Because that sounds like a condition precedent to becoming Commander-in-Chief.
Well, there are two different hats that the president wears. He's Commander-in-Chief of the Army and Navy of the United States at all times. That would still be subject to the regulations that Congress writes for the control of the Army and the Navy. Right? The president doesn't determine that, Congress determines that. And it would also be subject to the power of Congress to declare war and to fund military operations. The other hat that the president wears is he is commander-in-chief of the militia of the several states when called into the actual service of the United States. And that's because the power of Congress is a power to call forth the militia to do three things: execute the laws, suppress insurrections, repel invasions. And the militia are entities of the states. There is no militia of the United States. There are the militia of the several states. So there are 50 of them. He's the commander-in-chief of those 50 militia when all or part of them are called forth by some statute enacted by Congress. So just to anticipate what we might talk about later, if you look at the problems that we're having with rioting and looting and so forth going on in various municipalities and states right now, the authority of the president to call forth the militia to deal with those problems is set out in certain statutes. And those statutes were enacted by Congress pursuant to its authority to call forth the militia, let's say, to execute the laws and suppress insurrections in this case. So it all fits together perfectly. The president can't do anything with the militia unless there's a statute of Congress that allows it and tells him when to do it. With respect to the Army and the Navy, he has a little more leeway because Congress will give a certain command structure and assume the United States is attacked. So assume we have a Pearl Harbor type episode. The president wouldn't have to wait for Congress to declare war to tell the Army and the Navy to defend Pearl Harbor or to retaliate against the Japanese fleet or whatever might have happened under those circumstances, or today, similar circumstances. Whereas if the president wanted to use the militia, he would have to look specifically to a statutory authorization from Congress to do so. And they're there. It's not that we're waiting for them to be enacted. They're there. They have been there since, what, 1795? Long time. Right? They're just not used that often.
What about if there is no Pearl Harbor and the president wants to knock off some leader of some country somewhere or some gang somewhere, and he wants to get the military to send bombs to wipe out this individual or individuals? Does he have the power without Congress to do that?
I would say no. He's going to have some kind of authorization that would enable him to make a finding that that individual or group was a direct and imminent threat to the United States. And then that would come under some regulation of Congress dealing with the use of the Army, the Navy, the Marine Corps, the Air Force, whatever.
Well, wouldn't that make the Iraqi war illegal?
Well, you get into some questions there about whether the Iraqis were attacking, they attacked Kuwait. They're threatening Saudi Arabia and other countries, right, with which we have treaty or other obligations. So that becomes another question as to whether there were those provisions at the present. But let's just talk about the assassination problem. And that's one that's significant because I think Mr. Obama's people made the claim, Eric Holder made the claim, that power could be used against Americans within the United States. There's a provision in the Constitution that says no bills of attainder shall be enacted. Now, what's a bill of attainder? A bill of attainder is essentially a legislative determination that something very bad can be done to a particular individual. And typically it was the king turned against some noble, they passed a bill of attainder in Parliament, and that noble was executed, exiled, whatever it might have been. His property was seized, right? Without trial. This was simply done. His name was put on a list, and these bad things happened to them as a result of a parliamentary determination, or today it would be a congressional determination. Well, that's outlawed. That's outlawed for Congress, that's outlawed for any state. So Congress couldn't do it directly, and Congress couldn't delegate that power, which it doesn't have, to the president. Couldn't say to the president, well, we can't draw up a list, but you can draw up a list to kill people. It's completely unconstitutional. And you can leave aside the whole questions of due process and all the rest of that, trials and everything else. A bill of attainder at any level of the government is simply unconstitutional. End of discussion. You would have to show that the particular individual or group, as I say, was an imminent threat to the United States. So that self-defense comes into play there. There's always the power of self-defense. That's a natural law right of both an individual and a community. But I would say you would still need to have some very specific statements coming out of Congress. What are the circumstances? What are the standards that have to be applied? What are the findings that the president has to make? He has to make a determination of fact. And only after he's done all of those things, checked off those boxes, could he take that kind of action so that he could be held responsible after the fact if what he had done had not been justified.
Since we're talking about executive power, G.W. Bush, or Bush, as I call him, when he announced that he was going into Iraq because of quote unquote weapons of mass destruction, he said, and I quote, "We are going into Iraq to enforce a UN resolution." That was the reason he gave when he announced it publicly. Does he have the right to enforce UN resolutions?
Well, the UN cannot require, the relationship between the United States and the UN is one of treaty, and no treaty can override the Constitution. So the UN cannot authorize, let alone require, the President of the United States to take any action which would be in violation of the Constitution, or even arguably in violation of the Constitution. Because as soon as that comes forward from the UN, the president should turn around to his own advisors in the Department of Justice, turn around to Congress maybe and say, I've got a problem here. I don't know what to do. What do you want me to do? You, Congress, have the ultimate authority here. Congress has passed a statute tomorrow morning declaring anything that the UN has done or the entire UN relationship with the United States as gone. They can simply abrogate that treaty. Say, we're not going to follow that at all. So the president's put in an interesting position there because the UN takes, I guess they take the position that resolutions that come out of the Security Council or maybe the General Assembly are somehow binding on the members of the UN. And maybe they are with respect to some members of the UN, but not here. The Constitution controls, not a treaty.
Yeah, I think in the UN Authorization Act, I think that may have been 1945, but I'm not entirely sure of the date. Basically, that law indicates that the United States cannot go to war without UN permission.
Well, they can't limit by statute the power of Congress under the Constitution. That's rule number one. Rule number two is that you can't by treaty limit the powers of the government of the United States. So I'm not sure. I think that was one of the reasons why Senator Bricker, remember the famous Bricker Amendment proposal, which was to say that no treaty could limit the Constitution of the United States. And I always thought of that as a very dangerous argument that he made, because that was already true. You could look back in the 1800s and find cases of the Supreme Court which say no treaty can limit the Constitution of the United States. But that was his worry, that here was the UN and some people in the government, I guess that was Truman administration, wasn't it, at the time, some people in the United States government which were accepting this concept that if the UN said it, that we had to follow it, in the sense that there was now a world government, in the sense that term is used today, as opposed to this treaty arrangement among a number of countries who had joined this organization, like the League of Nations concept, right? I think that was the worry. And I don't think enough people look at this from what I would call the strict constitutional point of view and realize, wait a minute, this thing is a creation of treaty. It cannot override an inconsistent congressional statute. So if you have a treaty obligation, something comes out of the UN and there's a congressional statute that's contrary to it, forget the UN, the statute controls. If you have something coming out of the UN that directly impacts on the Constitution controls. If you have something coming out of the UN and you have a statute from Congress agreeing with what's coming out of the UN, but that contradicts the Constitution, then the Constitution controls.
Yeah, it's interesting. When I talk to Democrats or Republicans most of the time, and I'm criticizing the government, as I'm wont to do on a regular basis, they always say to me, oh, it's by treaty. It doesn't matter if it's constitutional, it's by treaty. Most people think that a treaty is above the Constitution.
That's what Bricker was worried about.
Right. Very dangerous. Yeah. On another note of federal power, let's discuss this whole mask nonsense, to me nonsense, where the government, first of all, Trump declares a national emergency. And all of a sudden you have all these various so-called leaders at the federal, at the health agency level, at the state level, simply declaring, there's certainly not any written legislation passed, that you can't sing in a church, you can't go to a church, Jews can't have a funeral. If you saw
I saw that, right?
Went berserk. In fact, I saw de Blasio order the police to storm a Jewish synagogue in Brooklyn, and he sent 4 squad cars there because the Jews are required to have a minyan in order for their prayer to be ultimate power. You got to have 10 Jewish men in a minyan. Right. And so naturally there's 10 people. And Trump sent sent squad cars there to stop this imminent danger. What is your response to that?
Well, I wonder how he thought he would get away with that with the biggest Jewish city in the world, number one. That's a little bit difficult to understand what his thinking was. But if you're looking at this from the legal point of view, there is no general concept that something called an emergency overrides state law, federal law, or the constitutions of the states or the government of the United States. You look in the Constitution of the United States, the word emergency does not appear. The word necessary sometimes appears, but the word emergency does not appear. Usually what they're talking about is Congress or state legislatures passed some statute, and they have defined in some way in that statute what they're going to call an emergency situation. And they say that under this emergency situation, the governor or the president or some executive official will have the following authority, boom, 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 boom. And you look at that and you say, all right, we don't need the word emergency if the legislature can give the executive branch that authority. Doesn't matter what you call it. You can call it an emergency, you can call it something else. Emergency does not create power, but the use of that word attached to some statutory set of standards that authorize the use of power within the constitutional authority of a legislature to grant is just a trigger mechanism. It says, oh, when this happens, and we're going to call it an emergency, then you, the governor, can do this. And if the governor could do that anyway, without the word emergency, then we have no problem. The word emergency adds nothing to it. What they're attempting to create is this concept that if an executive officer, not necessarily the governor, it could be one of these public health officials or somebody at a lower level, if he says something is an emergency, therefore all bets are off, and he can do anything he wants, give out any orders he wants, and everyone has to follow them, even though there is no statutory basis for this. Now, sometimes they do it by extrapolation. So you'll find a statute that will give certain emergency powers to a governor, or certain powers to the governor labeled as emergency powers. And then he will extrapolate from that and he'll say, well, not only do I have these, but I have others. Kind of interstitial interpretation here. So that's an invention by the executive branch based upon the existence of a statute. If you look at these masking orders, the social distancing orders, the number of people who can be in a group, and you ask, well, what's the basis for that? Well, the basis for that has to be some sort of scientific determination. We're talking about public health. We're not talking about Ouija boards, if you will. There has to be some scientific determination. And it's a scientific determination which is based upon a set of facts that have been established through the scientific method: verification, falsification, experimentation, and so forth. So if you're in a legal contest here, let's say that I'm going to challenge the masking requirement that we have in Virginia. I go into court and I say, these people are requiring me to do such and such, which is a clear violation of my liberty, constitutionally protected. It's a due process violation, unless what? Unless they can show as a matter of fact, number one, that they, as a matter of law, number one, that they have the authority. There's some statutory authority for them to do this sort of thing. And then number two, that as a matter of scientific fact, what they have done is proper. Now, none of that's been done in these cases throughout the states, right? When has anyone ever gone to court, challenged an executive or other public health official and said, you have the burden of proving this, which is true, because that factual predicate for what they're doing is what the courts used to call, I suppose they still do, constitutional fact. If the court is going to make a determination on the basis of a constitutional right being applied or not applied, and the predicate for that is some set of facts, those are constitutional facts. Those facts have to be determined in order to make the legal determination on the right that's involved. And who has the burden of proving those facts? Well, it's the proponent. It's the person that's saying these facts exist, and as a result of that, I'm giving out a mask order, I'm giving out a social distancing order, whatever it is that he's put out under the emergency protocol that he claims to have. We've never seen that happen yet. And I'm surprised that it hasn't, that someone hasn't gone into court, because there is, on the masking aspect, for instance, there's a tremendous amount of scientific literature that says this doesn't do what they say it does, what certain people say it does. In fact, it could be harmful. It's either useless or harmful, but it certainly doesn't rise to the level of preventative medicine, if you will, that would justify the level of imposition. That's probably also true of social distancing. It's probably also true of many of the other things that have been done. One thing is a classic example, the hydroxychloroquine, azithromycin, zinc protocol. Wasn't it Dr. Zelenko? Remember Dr. Zelenko?
Yeah.
In that upstate New York, was that a Hasidic community? It sounded like it had an interesting name.
I think it was, yes.
I think it was a Hasidic community. And he came out very early in this pandemic and said, I have treated 100 of my patients with this protocol, and every one of them is fine. And then later he wrote an open letter to President Trump saying, I have treated whatever it was, 300 or 400. Man had a terrific record. And there are many other doctors, but he was one that was kind of prominent, at least in my searching of the news. There have been many others. And they have run into this difficulty. I guess he didn't, he just did it anyway. But in various states, the governors or the public health officials or the medical licensing people have told the doctors, you are not allowed to prescribe this drug or this set of drugs for this purpose, period. And in some states, I understand they've told the pharmacists, if you get a prescription for this, you're not allowed to fill it. Now, here's the interesting question. I'm a doctor, let's say, I'm a medical doctor, and I want to prescribe to my patients based on informed consent. I've told them everything they need to know, the hydroxychloroquine protocol. But the public health people tell me that if I do this, I'm going to lose my license, I'm going to be enjoined, maybe I'm going to be held criminally liable, or misdemeanor conviction, or some other darn thing. So as a result of that fear that's imposed upon me, I don't exercise my right as a doctor to deal with my patients to my best ability. The patient doesn't get the drug. The patient dies. Now, both the doctor and the patient have been deprived of federal constitutional civil rights. That's a criminal violation under the laws of the United States. Title 18 of the United States Code, sections 241 and 242. Do you know what the penalty is for violating those two sections when death results to the victim? No, you don't. You give me a quizzical look, Bob. I know you don't know. The penalty is death. The penalty is death. All right, that's one of them. And it could be imprisonment, but the judge is capable of giving the death penalty. So you look at one of these situations and you say, oh my gosh, why hasn't some doctor come forward, gone to the Department of Justice, or a group of doctors? A number of them were on the steps of the Supreme Court a few days ago talking about this problem. Why haven't a number of them gone to the Department of Justice and said, look, we've been prevented by whoever it is, these public officials, governors, whoever they are, from using this medical protocol, and our patients have either died or suffered terrifically, physically, which would also be a violation of their constitutional rights. And we want you, Mr. Barr, in the Department of Justice, to get some of those smart guys, the lawyers that you have on call, and look into whether certain of these public health officials shouldn't be prosecuted. If I were the President of the United States, that would already have happened. In fact, some of them would already be in front of grand juries.
And hopefully executed as well.
Well, I'm not so concerned about that. I mean, there are penalties, 10 years, 15 years, huge fines, whatever. I'm just saying, it's so, and you know why that statute was passed? To deal with the Ku Klux Klan. That's why the death penalty was there. You know, the Ku Klux Klan was engaged in this kind of activity, and they were killing people. And so the death penalty was imposed.
Well,
but
you know, my question always is, who the heck is the government or any of these quasi-government agencies to tell a mother and father and their doctor what kind of treatment their child should have? And that applies to people who choose to have natural medicine for their kid, or they're passing statutes all over the place that if parents have a kid who's having sexual, quote unquote, identity problems, they're not allowed now to bring them to a psychiatrist. The government is going to make that illegal and then go after the parents and go after the psychiatrist, which to me is a total interference in the doctor-patient relationship.
Well, it's child abuse on top of that.
Yeah.
Right? You have a child that has this kind of an emotional problem. You want to get it treated by someone who's competent, and some bureaucrat steps in. No, we're not going to let you do that. We're going to make it. In fact, we're going to make it worse for you because we're going to interfere in your life in one way or another.
Yeah.
And that's the technocracy problem. You know, the whole business of administrative agencies, which started at the turn of the 20th century, was based on the concept that democracy doesn't really work. You know, people who think they have rights, and they're deluded. And what we really need to have is experts running our country, the people who really know. And
like the Federal Reserve, right?
Like the Federal Reserve, like the FDA.
They've done a hell of a job.
Okay, we excellent. But this was the theory. And we're going to get Congress to enact statutes to create administrative agencies and staff them with experts. And after that, the only role of the people will be electing people to Congress who will pass more legislation, giving us more power in the agencies and giving us sufficient money to exercise those powers. And we, the technocrats, the people whom you can't criticize because we know more than you do, right? You're the ignorant masses. We're the guys that went to Harvard. We know what's going on here. You will do exactly what we say. And if you don't, then our stooges in the legislatures and our stooges in the executive branch will pass and enforce laws against you to penalize you or in some other way, you know, punish you for not following our dictates. And so we see this in the medical profession. This is the last place that the bureaucrats should be interfering, the doctor-patient relationship.
We're starting to run out of time, but I just want to touch on Gorsuch and Roberts, who was to be, you know, the Republican judges who follow the Constitution. They ruled in this case where a fellow was working for a funeral home. This is a recent ruling. And he wanted to come in to work in a dress because he was changing, quote unquote, his sex. He was a transgender. The boss said, no, you can't do this. It's a funeral home. We have a dress code. The men must wear suits and the women must wear business female attire. Right. And he took it to the court, and the so-called conservative judges ruled against the funeral home. Can you comment on that?
Well, this is an example of the tyranny of precedent. Right? You go back and a bad idea gets insinuated in a single decision, And then based on the concept of stare decisis, which is let the earlier precedent stand, let's follow the earlier precedents, that decision metastasizes because there are lawyers who want to push that line of argument as far as it will go. And in our society, unfortunately, that line of argument with respect to transgenderism and some of these other questions that are related has the big media behind it. And judges, they don't want to be unpopular. That's number one. They want to be seen as somehow in an elevated position that is advancing the basic principles that society today accepts. Well, as those principles become corrupted, if you have that mentality as a judge, if you're not, what should I say, courageous, let me use that word, if you're not courageous enough to stand up against the tide, then what will you do? Well, you will fall back on these precedents and expand them slowly but surely, because once a bad precedent, the logic of a bad precedent is there, it expands all by itself. Justice Jackson said that with respect to the Korematsu case. Remember the Japanese concentration camp situations? He said, this is a very bad precedent. And once you let something like this into the law, it will have a life of its own. And it will expand in only one direction. It will never contract. And so that's what we're seeing. Transgenderism is an example of some of these really bad social ideas being injected as legal principles that no one can question. That was the problem. It was fine when people would say, all right, everyone has a right to an opinion. We can't suppress this opinion. If you believe in transgenderism, you're entitled to say it. This is America. But you can't make it a principle of law that stops me from questioning it or stops some parent from trying to protect his child against it by using whatever facilities or psychiatric care may be available. That is not what our law is supposed to allow. Unfortunately, once again, as Jackson said, once the bad principle is insinuated, it tends to have a life of its own and expand like bacteria on a Petri dish until it reaches the end of the medium.
Well, Edwin, I could talk to you forever, but unfortunately, my Zoom time is running out.
Thank you, Bob.
I'd like to, in the future, do a whole show with you on the militia and the Second Amendment, because it really needs to go into a deeper discussion. But
that's right.
You are absolutely a national treasure, which is why you're never going to be asked to be part of any administration.
I think that's the consequence of national treasures. They're always buried.
Yeah,
right.
Exactly. If you're not Larry Kudlow, you're or Steve Mnuchin from Goldman Sachs,
right.
You're not going to get a job.
That was my basic mistake, not getting involved with Goldman Sachs. Then people would be listening to me.
Yeah, exactly. I was talking to one of Trump's friends way back, and I was telling him if Trump has any brains, he should absolutely ask David Stockman to be head of Office of Management and Budget, because David Stockman, compared to what they have in that administration, there's no comparison. He had the ear of the president, and for some reason they never asked David Stockman to be of help. And even though he's not a big Trump fan, he's the type of person that if the president of the United States asked him for help, he's not going to say no.
Well, you want some people of contrary opinions around. You want Team B, right?
Yeah, I would think so. But unfortunately, they have pandering genuflectors and gatekeepers instead.
Right, exactly.
But God bless you, Edwin Vieira. You're doing a wonderful job, and may God keep you alive like Abraham for 125 years? Yeah. And all the best to you and your family.
Well, thank you, Bob. I appreciate it.
All right. Take care.
Take care.
Okay. End meeting.